to GenFriends. I'm your host, Cheri Hudson Passey from Carolina Girl Genealogy. And with me tonight always is this fabulous, fabulous panel. We've got Dan Earl, a family history guy. Hi, Dan.
Hello.
So glad you're here. Can you guys tell we're recording this around Christmas? And we have Melissa Barker, the archive lady. Hi, Melissa.
Hey, how's everybody doing?
We're good. We're good. Yeah, we've got Mary Kircher Roddy from MKR Genealogy. Hi, Mary.
Hi there.
Good to have you. And Shelley Murphy, our family tree girl.
Hello.
And Bernice Bennett. Hi, Bernice from Genealogy.
Hello. Hello.
Now we'll have some questions from Laura, but unfortunately Laura had a finger incident crafting and she's actually getting stitches. So as we film, so she's been sending Melissa a question or two. So Melissa will be her voice tonight and we miss her. But guys, do you see? And for me, she's in the middle of the screen. I don't know where she is for you. But our very, very special guest tonight is the legal genealogist herself, Judy Russell. Hey, Judy. We need. Dan, do you have your clap? Your machine?
Good to be here.
Listen to. Okay, Dan. Is it going to work?
Oh.
Well, okay. I didn't hear it. So, well,
I didn't hear the clapping.
I didn't either, so I did it myself.
Oh, that's weird.
No, we didn't hear it. Try it again. One more time.
All right, one more time.
One more time.
There we go.
There we go.
We're
Okay.
normal, Judy.
Well, I don't know if we're normal, but you know.
We're genealogists. What's normal is a setting on a dryer, right?
Exactly. Judy, we wanted to bring you on and talk to you, of course, about copyright. I think we all have issues with it. I worry about copyright when I'm putting a little Merry Christmas thing or Happy Halloween thing or anything like that on Facebook, you know? So I think that we all are more aware of it than we ever used to be due to you and your diligence. So we all have had some issues, but I know Dan had a really interesting one and that kind of got us thinking about seeing if he would come on the show. Dan, what was your?
Yeah, so so our county archives where I live is in the same building where my kids used to play floor hockey, which is like ice hockey for poor kids. And I had taken them to practice. It was the one year that I wasn't coaching, and so I was just sort of walking through the halls, and it was, you know, like any good genealogist, was sort of peering through the window of the county archive just to see what they had, and sort of walked around to the front door, and they had a bulletin board next to the door, and lo and behold, on that bulletin board, right out for everybody to see and access, was a copyrighted handout that I had created for a talk that I'd given to another organization. And so I unpinned it from their board and put the pin back and wrote a nice little note about, please, before you post somebody else's copyrighted material, please check with them first, and then left that in its place. And then took my handout home. So.
Yeah, that's about as obvious a copyright violation as you can get. I mean, they could have conceivably put it out on the internet, which would have been worse. But yeah, there's such a lack of understanding of, first of all, the value of what genealogists do and the handouts that we produce and the talks that we give. And I think that feeds into it. There's an expectation that, well, this is just family history, so it should all be free. And that feeds into it. But the law is very much to the contrary. The minute that Dan created that, he got a whole set of legally protected rights. And they're called exclusive rights. He's the only person who can decide whether to allow copies to be made at all, how they're to be distributed, who can distribute them, who can display them. Those are all legally protected rights the minute that he produced that handout. And why people don't get that, I really don't understand.
I don't get it either. And I know I've had picked up other places' newsletters before and seen them copy something from maybe Ancestry.com, a column right into their little newsletter. And I'm thinking, oh my gosh, you can't just do that.
Well, some of it you can, and this is where I think people kind of foul themselves up. They don't get the difference between something that is licensed for a purpose. There are Creative Commons licenses now for lots of materials that are put out on the internet. All of us, I think, as genealogists are familiar with the shared centimorgan project that Blaine Bettinger put together. And all of the materials that he created under the shared centimorgan project, he released subject to what's called a Creative Commons license, which means we're allowed to use it without asking his permission, as long as we live up to the terms of the license. So some of those sorts of things, including things that Ancestry or some of the other organizations put out, are available subject to the license. But the obligation is on us to check before we just use it.
Absolutely. There's not, oh, I just didn't know. That doesn't cut it, right? That doesn't cut
Not anymore. It used to, because under the old law before the 1970s, there were things like you had to put a copyright notice on it. Or you had to register it with the Copyright Office. That's not true anymore.
Yeah. And I don't think a lot of people know that, right? Yeah.
Well, you would think that people would know it because we keep saying it over and over. But then you get the people who say, well, if you don't want it copied, don't put it online.
Yes.
Can you imagine saying that to like Disney? If they won't say it to Disney or MSNBC, why would they say it to anybody else?
That's a good point. Okay, that's your bar, people. If Disney wouldn't do it, don't do it. If Disney's not sharing, you better not just copy anybody else's stuff. I like that. Yeah. Melissa, do you want to ask Laura's question?
Yeah, I can. She says she wanted to ask Judy about song titles versus lyrics.
Titles in general, titles associated with lyrics are all going to be subject to a single copyright. But titles, company names, things like the Legal Genealogist, if they're protected by trademark as opposed to copyright. So it's a song title by itself, Yesterday. I mean, how many songs are there that are Yesterday or Blue Moon? All right, maybe You Ain't Nothing But a Hound Dog is a different story, but some of them are just so generic that they're not going to get protection unless they're with the lyrics.
Okay.
So there's a difference there.
Well, that makes sense. Sometimes you just wonder, does this make sense? Like, I don't want to, and then you get afraid, to share it. But you were talking about the copyright. I still always put copyright on everything.
You see,
because there are people that will say, well, it didn't say copyrighted, because they don't know that you don't really have to anymore. As long as you've published it, then it's yours.
Correct. And all of your unpublished materials have the same degree of protection. But if you want to have a fighting chance in this, forgive me for using the term, but selfish world, where and people think anything that's out there is good for them to glom up. If you want to have a fighting chance, then you want to make sure that you're putting the notices on and protecting your own work.
Mary, you have a question about adding pictures to Ancestry?
Yeah, so if I have a tree on Ancestry and I have a photograph that somebody gave me of an ancestor, don't know who took the photograph, can I attach that to that person's, to a profile in my tree?
You certainly can. The issue is whether it's wise to do it in a public tree as opposed to a private tree. The issue in almost all cases is going to be, is there any realistic likelihood that the person who took the picture is going to surface and be upset? The photographs that were taken by my grandmother, for example. Now, she died in 1995 at the age of almost 96 years old. She would no more have objected to anybody using one of her pictures. If it's one of her grandchildren or one of her children, then she would jump off the top of the Empire State Building. Although I share the copyright with 9,000 cousins because she didn't leave a will, I'm not worried about those photographs. But for example, a studio photograph from 1930 or 1940 could very well still be copyright protected by the photographer or the person who paid for the image. And I just don't want to have to answer to that person.
These are, snapshots that somebody took on the street. I mean, I can't imagine even the heirs who own this would have any idea that it was their grandfather who took this picture.
I think a lot of it is risk-benefit analysis. What we're doing is honoring the person who took the picture. So to the extent that we know, we're genealogists. We all use the genealogical proof standard. What's the second element of the GPS? Cite your sources.
Okay.
So we cite the person who took the picture if we know. If we don't know, one of the things we can do is invite people to tell us. Now, this is a photo that's been floating around in my family. I don't know who took it. If you do, please let me know. I'd like to credit it. That I think is fair game as well.
And I've been working on a presentation and I'd like to use the photos in it, but I'm not going to because I don't know who took them. But if I point people to the family tree with this person in it,
you've got a little bit more protection there, but not a whole lot because you're now limiting the universe. You actually may be expanding the universe by having it on Ancestry than in a single presentation.
Okay.
But remember that the copyright only lasts for 70 years after the person's death. So if you've got any photograph where the likely photographer probably died around 1950 or earlier, you should be okay.
Yeah, mine died like in 62 and 99, the potential one. So I got it's a long way to go.
But crediting as much as you can is one step you can take to make it less likely that somebody is going to object.
Okay.
But we do have a problem here in the United States, and it's a very different problem than they have in Europe or the UK. And that's with all of these things where we don't know who owns the copyright. It's got a technical title. They're called Orphan Works. And even with diligent effort, we can't figure out who took the picture. In the UK and the EU, the European Union, there's a licensing system where you pay a small fee to a licensing service that the government runs. And if the owner ever surfaces, they can object to any future use and collect the license fee. Our Copyright Office proposed a scheme like that to Congress. And I'm not going to make any snotty comments about how quickly Congress acts on things like that. But the report was written in, I think, 2005. It's now 2020, almost 2021. And of course, they've done nothing. So this is a real problem for us. We simply have to do a risk-benefit analysis on these orphan works and hopefully stay within a fair use analysis.
Dan, you
Okay,
said sorry, Mary. Dan, you said you had a follow-up comment to Mary's question.
Yeah, so it involves just kind of staying on the topic of Ancestry. So Ancestry has a large collection of yearbooks that contain a number of images. That seems to be, based off of what we've been talking about, it seems to be particularly a sticky situation to kind of work through in terms of tagging ancestors and bringing those images into a public tree. Is any advice on how to navigate that without
that one I think is probably a lot easier for the individual genealogist, because you're within the universe of the Ancestry system. And they've posted these images, and the Ancestry system is set up for you to share from those pages. So if there is liability in that circumstance, I would think the liability is going to rest with Ancestry, not with the individual users who are using what Ancestry has put on. Now, having said that, you should know that there's a lawsuit that's just been filed in California under the California privacy statutes by two people who are in those yearbook photos, who are objecting on the grounds that Ancestry is using their images for commercial purposes, and they're not getting paid for them. That's a California statute, and we'll have to see how that plays out. But yeah, that's already under attack. Many of those yearbooks, though, were never copyrighted. I looked at my yearbook. Now, I skipped my senior year, so I don't have a senior year photograph, thank heavens. But I looked at that year, and there's no copyright assertion in that volume, and that was a time when you needed one. So the book was never properly copyrighted. Those images, to the extent that they were willingly contributed, are out of copyright. They went into the public domain by virtue of their being published without a copyright notice. And that wouldn't happen today, but it did happen with those older books. So that's why this is such a complicated issue.
Now, we were talking about the Ancestry yearbooks, and because you said Ancestry was set up for sharing, what about all the rest of the documents? They're like, say, on Family Search, Ancestry, Find My Past, everything that's on those are, I know we need to cite them, but just for people who are wondering, what's the copyright? Can we put them in blog posts? Can we use them in presentations?
There are two issues with respect to everything on every website. Number one is copyright. Now, a huge amount of what is on Family Search, Ancestry, and other websites is not copyrighted. For example, anything produced by a federal government employee for the United States federal government cannot be copyrighted. There's a specific section of the statute that says not happening. So all of the census records and the immigration and the naturalization records and all of those sorts of things, all of the judicial and court records of the federal government, absolutely copyright free. Now at Find My Past, you have the exact opposite. You have something called Crown copyright, which is asserted by the British Crown in documents produced for the British government. Now there's what's called an open government license, where they allow a lot of the use under a copyright thing, but it's like a Creative Commons for the British government. So that's the copyright part of it. A lot of things are out of copyright. On top of that is what's called terms of service. And that's not a copyright issue. That's a contract issue. So the example that we always run into as genealogists is newspapers.com on one side and Genealogy Bank on the other.
Yes.
Okay, so Genealogy Bank has a lot of the same newspapers as, let's use an easier one. Let's use Chronicling America from the Library of Congress, because it's got the best terms of use for a genealogist. So Genealogy Bank says in its terms of use, you can use our service for personal research only. Don't copy, don't reproduce, don't publish, don't put it in a blog post, don't put it in a presentation without specific permission. Now find the same clipping from the same newspaper on Chronicling America and it's fair game, because both of them are out of copyright, but one of them has a contract that you agreed to in the terms of service, where you said you'd only use it for personal use. So that's an overlay, and people confuse that. They say, well, how can you claim copyright on a 1920 newspaper? They're not. They're saying, this is our copy, and if you want to use our copy, you have to abide by our rules. It's contract.
Is there a difference with taking the image of the newspaper article versus transcribing the newspaper article?
Bank. Genealogy Bank has the most restrictive terms of service in the entire industry. Now, you can extract the facts, not transcribe, but extract. Okay. So if the article is, the beloved Reverend Elijah Gentry was laid to his last rest in Neshoba County, Mississippi last week, you can extract Reverend Elijah Gentry died Neshoba County date. And that's, nobody can stop you from using facts. Facts can't be copyrighted. But the expression of the facts, the word for word way that they're said, they can stop you from using if they're copyrighted. And if the terms of service say you can't do it, then you can't do it using their copy.
Interesting. You know, you were talking about terms of service. I'm sorry, Judy, were you going to?
Just going to say, always think of those two things, which are different, but they tend to overlap a lot.
Right. You wrote a post recently about terms of service, which I know was shared. I even was at a local club meeting trying to explain the same type of thing. And I said, you need to read Judy's post. And what it is people who will get into the different groups on Facebook or whatever and say, I don't have a subscription to a certain site. Will you please look this up for me? And then people do it. And that is illegal, actually.
It's, are we all going to jail?
I don't think so, because ordinarily these things are not prosecuted in a criminal court. It's civil. What they could do is cancel your subscription and refuse to give you your money back and not let you subscribe again.
Right.
They don't want to pick a fight with people. They don't want to take on the entire industry. But by the same token, and I can't say this often enough, some of you, I'm looking at Dan and Melissa and Cheryl, are a bit younger than I am. You may not remember when everything had to be done with a self-addressed stamped envelope or a personal visit to a repository. This notion of going online and being able to get the census records without having to look somebody up in a Soundex and crank the microfilm for the entire bloody county, somebody has to pay to make that stuff available.
Yeah.
The title of my blog post was, "There is no such thing as a free lunch." I want those features. I want the German baptismal records on Ancestry. I want the Scottish marriage records on Find My Past. I want the family search records and the Ancestry records. Somebody's got to pay the bill. They got to keep the servers running and the digitization on that. So if all of us, we're going to have one subscription for an entire universe and everybody just says, will you get it for me? Not going to work, guys.
Yeah, and people, they're just trying to help. I've got it. They can't afford it. I'm just trying to help. But there are places they could go to get it.
That's the thing. How many of us have local libraries where there's an Ancestry subscription? Ancestry Library Edition subscription. And Ancestry and ProQuest, which runs the Ancestry Library service right now, have been bending over backwards during the pandemic to make things available.
Absolutely.
So we're going to pay them back by stealing? And that's what it is. It's theft. If you're not abiding by the contract and taking a copy and giving it to somebody who says, well, I don't want to be bothered getting a library card. I don't buy it.
Yeah, it's it's a tough thing, I think, for a lot of people to wrap their minds around, that they're not doing something right. But I like your example of it's the same thing as cable. You know, your neighbor gets cable, you don't, so you run your little cord over and you take their cable, you know?
You wouldn't mind giving me your Wi-Fi password, would you?
Exactly.
Yeah, actually I would.
Yeah, you know, you don't do that. Shelley, you had some questions, and then Dan had another one.
Yeah, well, one about the photos, you know, you basically answered that. And the question was really about, we know the person is deceased and they're off on the internet and Pinterest or whatever it is. And so I got the gist of that, you know. But another question was, what about going to the archives? And Melissa can turn her head, but we receive information, we receive photos. And I know, like at the archive, Historical Society where I'm president at, you know, we stamp things, and even stuff, if I go to special collections, you can't take a picture of it without putting this, you know, little strip of paper which says where you got it, da 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 da. But a lot of places don't do that. And here we go as researchers or family historians, whatever, and we go in and we get copies of that information and we use it. And then the defining of personal use, and what does that mean to the average person? As a genealogist, my thought is, I'm just not selling it, or maybe if I use it and I'm getting paid for it, you know what? And so my question would be and I think that's important to understand what personal use means.
Right. That means
so that was the other question.
Personal use, literally, to be 100% protected, means don't share it.
Right.
You use it yourself, and you don't share it. You don't give it to somebody else. You don't put it in a blog post. You don't use it in a presentation. You don't put it in your family history book. You use it yourself. Now,
just for your eyes.
If you want to share it, it is your personal obligation, not the obligation of the repository. Your obligation to know what the limits are on that document before you share it. Absolutely. It's really the sharing.
Yeah.
It is. It's the sharing. And one last thing was really the process. So us as genealogists, I know on the little icons and stuff, sometimes you pay, sometimes you get their permission. Should we, and again, I might have the big question mark, you know, with the white dome line and the royal blue question mark, and I paid for those. But should I start acknowledging on the slide where that's at, paid for, approved by type thing?
I don't acknowledge licensed items that I buy the license from a stock agency. I think that's overkill. Now, I know that there are people who do. I'm sure it will come as a shock to all of you that one of the people who does is Elizabeth Schoen Mills. Citation.
She does.
She does. She actually puts, you know, she will generally acknowledge even the licensed images. If you look at the Evidence Explained website, those licensed images, she indicates that they're licensed. I'm the editor of BCG's newsletter On Board, and we have agreed that our every issue says all images are either by permission or by license. We don't indicate specifically, but every one of them, we do know where it came from. Now, if it's anywhere other than my stock agency, I put a caption on it. I say this came from the Library of Congress Prints and Photographs Division, or this came from the New York Public Library, or this came from the Library of Virginia. Now, of course, with the Library of Virginia, using that as just one example, if you're in special collections, you sign an agreement. And if you want to use it, you tell them where and what publication and that sort of thing.
The archives down in Charleston, at the College of Charleston, you sign a paper going in saying you will not use it for anything except for personal use. But I did talk to him one day and I said, well, what if I just was wanting to, do a presentation and this was important to a blog post or whatever. And they said, well, they just contact us and tell us why you want to use it and we can give you permission. And they said, well, I don't, why is it this way? And they said, because people don't know how to cite and tell you where they've gotten their sources, where they've gotten these, photos of the original documents. And I thought, that makes a lot of sense. They want them cited correctly.
That's one part of it. The other part of it is, and I think Melissa can really speak to this, when people make donations of materials to an archive,
that gifted,
they may have controls and limits on what they've allowed.
Yeah.
And the only way the archive can protect itself and honor those conditions is by making everybody ask for permission so that they can say, we can give you permission on A, we can't give you permission on B.
Is that the facts of it? I mean,
No.
so I could use something, the information that I got from something in an archive.
Understand the facts by them. Let me give you an example, really good example, okay? Peter McCune married Christiana O'Brien in Monongalia County, Virginia in 86. Okay. How many ways are there to say that? I mean, you can put Christiana before Peter, you can put the date or the place first, but that's a fact.
Right.
Now, if I say he was dressed in a coat of blue faced with red and a macaroni hat like the soldiers wore. She was just 14, so young that a witness to the wedding advised her to roll up handkerchiefs and put them in her bosoms to make herself look older. That's the expression of the fact.
right.
Now you can extract Peter McCune, Christiana O'Brien, Monongalia County, Richards Fort, the whole works. Those are facts. The expression of the fact is totally protected.
That makes absolute sense. Thank you for giving us that example.
Can I give another example?
Sure. Yeah, go ahead.
I'm currently right now actually working on a project where a local resident has brought to the archives a 3-volume set of her photo albums. She's asked us to digitize them because when she's gone, she doesn't know what's going to become of them. She doesn't know if they will ever make it back to the archives to be donated because she's holding on to them right now. So we are digitizing these. Her instructions are that we are to digitize them. We can use them. She even gave us permission in writing to post them on Facebook, but the copyright stays in her name. So we label every single photograph with her name digitized as the copyright. And so that is one thing. Also, one thing that genealogists, I think, really don't look at or look over is when you're looking at a manuscript collection, and if there's photographs, documents, whatever's in there, when you're looking at the finding aid, we tend to skip all the way down to the contents listing. Don't skip all the way down to the contents listing, because at the beginning, we as archivists put together that finding aid, and up at the top, you're going to see copyright, and it'll say specifically, box 1 through 5 is open. Anybody can do anything they want to with it. Boxes 7 through 10 are under copyright, or the donor says this cannot be used, seen, copied, or nothing for 50 years. So it's important that you read the entire finding aid.
Yes.
Boy, is that the truth.
That's a great
The other thing that's important to understand, and again, Melissa, I'm sure is well aware of this, there are special provisions and special protections in the copyright law for libraries and archives. Section 208 of the statute gives archives and libraries a layer of protection that individuals don't have. So they could allow me to make a copy of something for my use, but what they can't do is give me permission then to reproduce it without going back and dotting the I's and crossing the T's.
Right.
Of the donor or the situation.
Even when we receive a donation from someone, we have them sign a deed of gift. And a deed of gift is a legal document which transfers ownership from that donor to the archives. Now, that doesn't mean that whatever is in those boxes, we can just do with what we please. We still have a responsibility to go through. And if there are photographs in there that are from a studio, we have to follow those copyrights. Just because the person who donated says it's yours, well, it's not really. We still have to follow whatever it is that's in those boxes, because I mean, it didn't belong to that person either, but you know, we still have to follow those.
Let's follow up on that, because Melissa just raised what is probably the biggest misapprehension of copyright altogether. And that is the notion that if I own the thing, then I own the copyright. And that couldn't be more wrong. Classic example. I am probably the world's biggest Harry Potter fan. I've got every movie, I've got every book. Now, the fact that I own that whole set of books,
Right.
you think I own the copyright?
No.
J.K. Rowling would come after me with a rolling pin. No, I don't own the copyright. But a lot of people think, my dad wrote these letters to my mom, and he gave me the letters when he died, so I own the copyright. Not if you got 7 brothers and sisters the way I do. He didn't leave a will, and that means we all share in the copyright. So owning the thing is very different in some very critical aspects for genealogists than owning the copyright itself.
You know, it was asked here about using a photograph from an archives in a presentation or in a blog post. I have an example of a local professor at Austin Peay State University, who's actually a friend of mine, was co-author of a book through a university press, and she was from this area, and she knew of a photograph from our archive she wanted to use in the book. So she asked for our permission, and I said, yes, sure, because there's no copyright with it. It was just a photograph. And for the publisher and I to get together, for her to use that one photograph, you can't imagine the paperwork that we both had to fill out. And so you're asking, can I use this photograph in a blog post or in a presentation? So
the reality is there's something called statutory damages. We all think, look, if I write a little story with a kid with a scar on its forehead and a place called Hogwarts, it costs $500 million in profits to J.K. Rowling. She can sue me for every penny of that. But now if I swipe a letter from Shelley and it's genealogy, everybody's sitting there going, well, how much is the damage? The answer is, from the statute, as much as $150,000 for a single violation.
Yikes.
You don't have to prove that the person lost a penny, as long as you can prove that they knew or should have known that it was copyright protected and went ahead and published it anyway. Wow. So the consequences are why we focus on this.
Exactly. Bernice, you had a question.
Right, and it concerns obituaries. And I have 2 examples. One is that when my grandmother-in-law passed away, she left this box of obituaries. And then a friend of mine's was just given all of the obituaries from a funeral home. The question is, how can those obituaries be used? And is there a copyright, or is it just fair use?
The facts that are in those obits can be extracted and used without limitation. The facts, the names, the survivors, the date of death, the place of death, the place of burial, the name of the funeral home, all of the facts cannot be copyright protected. But the word for word version of the obit probably is copyright protected. It was written by somebody from the funeral home, or it was written by the family, or it was written by the newspaper. Somebody owns the copyright. So the safe way to use those is to extract the facts and go with those. There's no way there can be any liability for that, with the single exception that you add something like, and we know she was the local hooker. Probably not a good idea. So you want to protect people's privacy from that sort of thing, but pure fact,
Regardless if people are dead or alive.
Yeah.
Doesn't it carry both ways?
well,
I know she's talking about obituaries, but what if you're writing a story about somebody that's still alive?
oh, well,
I wouldn't either, but
here's the bottom line. And boy, is this probably the best resource in the world. It's from the National Genealogical Society. It's on their website. It's in a part of the website that you can access even if for some inexplicable reason you are not a member of the National Genealogical Society. They are called their guidelines.
Yeah.
And one of those sets of guidelines is called Guidelines for Sharing Information with Others. So I'd give you the URL, except if you've looked at any of the URLs from the NGS website right now, they're about 9,000 characters long. So instead, go to the NGS website. Upper right-hand corner is the search box. Just put in the word guidelines. The first thing that comes up is going to be the whole set of guidelines. You click on that, and then guidelines for sharing information with others. And if there is a line in the sand in those guidelines, in those ethical norms for genealogists, it is protect the living.
Mhm.
Bottom line, anybody who's still alive, your story isn't finished. You may
Got
be
it.
the world's biggest rascal up till now, but your story's not finished. And you have the right to write the rest of your life in a different way,
Mhm.
and not to have somebody else come in and tell your story and perhaps not tell the whole story.
Mhm.
So we protect the living. We shouldn't be looking at things that happened 3 years ago, 30 years ago. We should be looking at things that happened 300 years ago,
There you go.
or 3 generations ago. I think by the time you're dealing with grandchildren, we all ought to be kind of like putting on our big girl panties and getting over it.
right.
You know, people made mistakes, and they're not ours, but they help make us who we are because they formed our parents and our grandparents. But if it's our own lives or a parent's life that's going to reflect on the child, or that the child would simply not want known, I'm not doing it.
Mhm.
Not without permission.
Right. I think we've all got those things in our trees, you know,
Of course
several.
we do.
We all do.
Mhm.
Absolutely. We need to respect that. And as you said, leave it alone.
The issue is, whose tale is it to tell?
Right.
And if it ain't yours, then we protect the living.
Mhm.
Do you remember the issue that came up with Harvard in the photograph of the person's ancestor who had been enslaved and this, that, and other? I don't know if that's resolved yet. I really hadn't come up with it, but that was a trail that was going on. Harvard was using a photo and a lot of their images around enslaved people and this, that, and other. And the family said, whoa, that's my 4th great grandfather, whatever the situation was. And that was in court. I don't know if it's resolved, so I
don't think
can't
it has
say
been- I don't think it has been resolved. And, you know, in a lot of those circumstances, we are dealing with exploitation.
yes.
Mhm.
And that's really the issue that needs to be resolved, is
Yeah.
whether somebody's pain is being exploited.
Mhm.
For genealogical purposes, it's much less likely to be exploitative as it is to be simply unthinking,
Mhm.
Mhm.
kind of assuming, well, I wouldn't mind. Well,
Yeah.
guess what? somebody else might, and
Somebody
it's
else
their
might,
story. We
Absolutely.
don't do it.
Absolutely. Does anybody else have any questions or comments or any? We
I
could
do.
sit here and talk to you all night long. Go ahead, Melissa.
I want to kind of maybe not end it, but I want to turn this into a positive note, because you know it can be kind of a downer. But I wonder if Judy and I know this just being an archivist too, and I know genealogists, we know this. Let's talk a little bit about what is out there
Oh, there's
that
so
is
much.
Here we go.
copyright free, that
Mhm.
like the Library of Congress, that they put so much out there for us to use, and other archives and other places. So can you talk to us a little bit about that?
Absolutely. And, you know, one of my favorite presentations, and I don't get asked to do it nearly often enough, is called Picture This, Images We Can Use, because there is so much out there. The Library of Congress is one. And if you haven't spent some time in the prints and photographs division, you know, think about the Currier and Ives engravings and how beautiful they are. They are all on that website, and they are all out of copyright. Every
I
image,
got the set of dishes.
every
from the
image,
A&P
every
store.
single image ever taken by a federal government photographer,
Yeah.
that absolutely spectacular image of the Dust Bowl mother.
Yeah.
Mm.
You all know, you've got it pictured right in your
Yeah.
mind. All I have to do is say those words.
Yep.
Out of copyright, taken during the Depression by a federal government employee. Think about, look at Mary Roddy right there, that wonderful image behind her head, probably taken by NASA. Out of copyright. National Oceanic and Atmospheric Administration, no copyright. There are unbelievable images on the Fish and Wildlife Service. You think of any kind of agricultural item you might want an image of. The Agriculture Department, the Bureau of Land Management, the Interior Department, the Defense Department, all of the government reports that have ever been done for the federal government, totally out of copyright. Anything, let me repeat this, anything legally published in the United States before 1925. Now, what's today? The 21st? In 10 days, 10 days, midnight, December 31st, when that ticks over to the new year, we get a whole nother year. Everything published before 1926 will be in the public domain. So there's a ton of material out there. Many municipal governments, the New York Municipal Archives, although they started pulling back a little bit on some of that, the state archives, the Library of Virginia, the Tennessee State Library and Archives, the Texas State Library and Archives, Mississippi Department of Archives and History. So many places have materials that are perfectly free of copyright. And one more place to look is on Flickr. That service that so many of us use for our own families, but there's something called the Commons on Flickr. There are agencies from all over the world. The Australian State Library, the Public Records Office of Northern Ireland, the National Archives of the UK, the National Archives of Sweden, in Africa, in Asia, in South America. Lots and lots of archives have gone through their collections and determined what items are likely out of copyright, and they've made them available on Flickr. Now, again, it's always our responsibility to double check before we actually republish, but that's a great place to look. There's so much goodie out there, and all of the things that are coming out now subject to Creative Commons licenses. So many people perfectly willing to have you use their work as long as you give them credit.
Absolutely.
Got it.
Absolutely.
Excellent.
That is a fabulous, thank you, Melissa. That is a fabulous way to end, is all the positive. instead of dwelling on all the things that we slip up and accidentally do things wrong, you know. And
There's so much that we can do that's good.
good.
And
Yeah.
bringing some of these old images
Oh, yes.
to life.
Yeah.
And you'll forgive me for this, but I love, and I know that it's a little hokey and that it's not entirely accurate, but I love those colorizations.
Oh, yeah.
The MyHeritage just turned the thing, the one from Vivid Pick.
Yeah.
These are wonderful tools to make some of these old images come to life.
Exactly. And, you know, it helps bring the younger generation in because, you know, a lot of them don't want to see anything in black and white. The
They
old
don't understand
Right.
black and
stuff,
white.
they don't. So to be able to put something in
Awesome.
color and see, you can see details that you didn't see before. So
Absolutely.
absolutely. But yeah, those wonderful old things that our kids and our grandkids may not know of that we can use in our blog posts and in our presentations to help people understand history in that way and not get ourselves in trouble along the way.
Also true.
And not have to call you, Judy, can I use this?
Please don't get into trouble.
Thank you so much for being with us tonight. This has been
Thank you for having me.
so
This
much
is such
fun.
fun. And I love the holiday spirit that everybody is showing. Shall I do it? Shall I give you my
Yes.
holiday greeting?
Yes, please.
Yes.
Here you go. Holiday Judy.
I am going to wish you all a very happy holiday season.
We love it. Thank you so much. Thank you. And with that, everybody, we will see you next time on GenFriends. Bye.